Lawyers of Reddit, what's the most laughable? I'm not a lawyer, but claim you've ever read? When I was a judicial intern, I saw an arraignment where the defendant claimed the court had no power over her because she was a sovereign citizen who did not recognize the federal or state governments. Later learned that her sole source of income was Social Security. I'm a lawyer in the US, and for some reason people are obsessed with common law marriage. I see people on Reddit and even hear them IRL warning other people about how you've lived with her for more than X years. You're common law married, so you have to take that into account. Or well, we've been living in the same apartment together for X years, so we are common law married now. Common law marriage is only a thing that can be done in a small handful of US states now, and there are requirements to it. You have to hold yourself out as being married, live together, present yourselves to the world as being married, etc. You're not going to wake up one day and accidentally be common law married. I once saw a defendant argue for a not guilty verdict because there was no Mr. or Mrs. Commonwealth who testified. Obviously the charges were Commonwealth v. defendant. He doesn't understand that. He was found guilty. The judge did not appreciate that. As a lawyer, I love seeing all of the Facebook posts telling Facebook what they do and do not consent to. It's the online equivalent of Michael Scott declaring bankruptcy. The most recent one I saw tried to cite the Rome Statute as justification. For those unaware, the Rome Statute is an international agreement covering war crimes and crimes against humanity. Ironically, for the Americans I've seen post that, the Rome Statute has never been ratified by the US. I found that Redditors are absolutely obsessed with correcting each other with the idea that assault and battery are often confused, and that assault only ever means to put someone in fear of imminent harm, to the point where, if I even point out that that is only true sometimes, in some places, I will be downvoted. Roughly a third of states define assault as some version of purposely, knowingly, or recklessly causes bodily injury to another. I made a similar comment right after you, so I just deleted mine. But yeah, it's such a silly correction to make. To be honest, I'm surprised it's only about a third. I figured it was a majority. My favorite was on advice for home invasion. According to the poster, you could shoot to kill anyone who comes in uninvited. Absolutely not the case, because self-defense by definition requires reasonable force. It's more lenient in some states and even more lenient in rural areas, but it's just irresponsible to spread this kind of misinformation. Edit. For anyone saying anything along the lines of nah, you can always use lethal force if, or nah, in this state. No, that's not what the law says. Anywhere. Reasonable force is an intentionally vague concept, and it's always interpreted case by case. Just because the defendant felt threatened doesn't mean a majority of the jury in his case would, even if this is usually the case. Stand your ground laws, castle doctrine. They exist to support defensive use of force, but you're always bound by reasonable force. And oftentimes, reasonable force can be lethal, but the judge and jury are the people who will decide whether or not you were justified. A group of people who may not share your same views put themselves in your shoes and decide if you did the right thing. The jury decides. Not you. Not your sheriff. Not your CCW instructor. If you're on trial for the use of force for self-defense, you absolutely shouldn't feel smug about it. The law has an unpleasant habit of surprising everyone. Stop making blanket statements about the law. If the law was black and white, we wouldn't need attorneys at all. Nearly every time patents come up on Reddit, people say something very wrong. Most commonly confusing patents, trademarks, and copyrights. But Reddit is very anti-patent in general, so people hate on them for all sorts of misinformed reasons. Even most lawyers know very little about patent law, because it is very niche, and not a topic on any state bar that I'm aware of. Also, saw a sovereign citizen represent themselves in a tax evasion case where they tried arguing something about the government only being able to tax his corporate self and no his personal self, so he had no obligation to pay taxes. I had a hard time following his arguments because it was so nonsensical. My favorite is, if you ask an undercover officer if he is a police officer, he can't legally lie to you. Yes he can. had an undercover in on a deposition once, and he had been wearing a wire for part of the investigation. He was asked if he was undercover by a co-defendant and his response was yay. Obviously, I'm here buying drugs from you guys cause I'm an undercover police officer. I have a wire hidden under my beard and everything, you ducking moron. He said it with such immense sarcasm they didn't think twice about it and sold him a trafficking amount of cocaine. For whatever reason, a lot of people do not understand that only the government, not private citizens or corporations, can violate your rights. The most obvious example is that Facebook, Twitter, etc. are well within their rights kicking Alex Jones off their platforms. A more complicated example involves the Fourth Amendment search and seizure rules. The police are not allowed to unreasonably search you. There's nothing in the Constitution barring a private citizen from unreasonably searching you and handing over any evidence to the police, though. My answer is actually basically all of the I'm not a lawyer, but claims. The funny thing about being a lawyer is that the answer is almost always it depends. Sure, the laws generally stay the same, but the outcomes are so contingent upon the facts that you can never know with certainty how something will turn out. Thus, my answer for 90+% of my clients is it depends on who the judge is, who shows up to testify, what the witnesses say, what theme opposing counsel goes with, etc. More importantly, we are not allowed to guarantee results, and for good reason. The simple fact of the matter is judges, juries, prosecutors, and opposing counsel can make different decisions based on identical facts and laws. I think the only time I'm not a lawyer, but would be appropriate is if someone is saying I'm not a lawyer, but you need to consult with an attorney. I'm not a lawyer, but I'm fairly certain that I could frame a dog for murder. Oh, I framed animals before. I framed a raccoon for opening a Christmas present. And I framed a bear for eating out of the garbage. One of my clients was told by someone on the staff of the nursing home where her mother lives that if an enduring power of attorney, basically a power of attorney made in contemplation of future mental incapacity, that unlike most powers of attorney does not become invalid if the donor becomes incapacitated, is voided if the original staples that held the pages together are removed. I can see a tiny grain of truth to this in that, if the validity of the document was contested, the fact that it had been taken apart and stapled together again might be some evidence to support that, but there is no way that evidence alone would determine the issue. And don't even get me started about people who use the term hearsay but don't know what it means. This has become an epidemic. On a first appearance for a criminal matter, the defendant going pro se, representing himself. Note, he is not incarcerated and only has to check in with the court once per week over the phone on release. I demand this case be dismissed pursuant to my 14th Amendment right not to be deprived from liberty. Judge, counselor, do you have a response? Me, without due process of law, which is why we are here for you to read Mr. Defendant his rights, Your Honor. My favorite, the judge cannot determine this matter because he is a member of the Freemasons, and the Freemasons do not believe in the concept of private property. This case ended with the non-lawyer accusing everyone of being a Freemason. The same non-lawyer also ran on appeal in that case, based on the fact that the judge was not a real judge because the judge had not taken his oath of office. The non-lawyer had dug up a transcript of the judge's swearing-in ceremony which read Judge Smith takes oath of office when the judge took his oath, instead of the actual words of the oath. The non-lawyer referred to outdated and repealed laws from 1730, which said all oaths had to be transcribed word for word, as a basis for the fact that the judge was not a real judge. If his interpretation was correct, I think no current judge in Australia is a real judge. I once had a person claim that within there was no such thing as the adversarial system, and that we were just trying to inflame a contested divorce. Should mention we live in a common law system and both parties had retained separate counsel. A tale from back in my public defendering days. Sovereign citizens are a special kind of stupid. Percentage-wise, I don't know how many of them are true believers, and how many think they've just found some clever loophole or another. At any rate, they were always the most interesting clients. One of them was a young gent who decided to represent another buddy of his to spin his nonsense to the judge. Unfortunately, the fellow who would become my client was a regular defendant in that same courtroom and everyone there knew he wasn't a lawyer. when he was arrested, which is to say immediately the judge was not swayed by his argument that he was acting of counsel rather than practicing law without a license. The operating a motor vehicle charge which would follow was only semi-related.